Hello, everybody, and welcome to Macro Pro and Friends. Today, I am joined by Debbie Wilson. Everybody knows Debbie Wilson. She's been in the industry for a very long time, as have I. So, Debbie, how are things with you?
Things couldn't be better right now. Super
Yeah?
happy. Yeah?
I understand you have a new addition to your family.
I do. I am now a grandma. Thank you very much. And I thought raising children was a great thing. Having grandchildren, there's nothing like it. I'm thrilled to have little Lincoln, 8 months old now. So it's been fun.
Oh, that's exciting. And you also have a new job. Tell us a little.
I do. I am now working with Allen Coben Compliance Solutions. They are a national Medicare set-aside provider, providing Medicare compliance, Section 111 reporting, conditional payments, Medicare set-asides to the industry, insurers, self-insured, TPAs, and also consulting if you need that as well. I've known Michelle and Kara for over a decade now, almost 2 decades, and I feel extremely fortunate to have joined their team. They're highly respected in the industry, and I'm very, very excited to be here and to help them with business development and bringing their information to all of you.
Oh, that's very good. Well, we're going to hear a little bit more about them and what they do. So before we get started, I've got a little bit of housekeeping to do. So today's webinar is worth 1 CEU. Just a reminder, you had to use the link that was provided to you because that's the name that is going to be on the certificate that you receive. You should get that within 2 hours. Download it immediately, please, so that we make sure you have it. Used to be I could help you if you misplaced it within like I think it's like a year or something, but now I only have about 15 days. So if you have an issue, please let me know immediately so I can help you out. The certificates, like I mentioned, will be coming to you within 2 hours. Sometimes it takes a while. You'll see this little blue circle go round and round and round. So if it doesn't populate immediately, give it a little bit of time. Otherwise, check with your IT department. A lot of times it is just simply a firewall issue. All right, we've got handouts for today's webinar, so please download those now so that you can refer back to it later. And then if you have any questions, go ahead and put them inside the question box. Mandy, who's in the background today, Farquhar, is going to be asking those questions, and then you can watch this presentation again on the Macro Pro YouTube channel. So Deb, why don't you tell us a little bit about the speakers, bring them on and introduce them.
Absolutely. I am honored to be able to present to you Michelle Allen and Kara Koba. Michelle and Kara have been in the industry for over 2 decades. They are trusted advisors to many clients across the country. They also both work in advocacy for the industry, which has really helped a lot. If you guys know, Kara is working with the MARC Coalition, and Michelle is working with the MSPN network. So they have really helped with the advocacy and helping bring our issues to CMS. And soon, next week, they're going to be at the MSPN, which is bringing Medicare to the table to discuss some of these issues and then some. So lots of clarity. Michelle and Kara, we're so happy to have you today and present on the new issues that CMS has brought in the final ruling on CMPs, which is civil monetary penalties. So without further ado, take it away. Thank you.
Thanks so much, Debbie. So glad to be here today. Thank you for having us. And we can get started in talking about Section 111 reporting and civil monetary penalties. Kara and I want to make sure that you know that we are a resource to you, and we've included our contact information, our email addresses, and our telephone numbers if you have questions about any of the content here or anything otherwise. And as Debbie had mentioned, we're both heavily entrenched in not only MSP, but also advocacy, being involved in these 2 organizations. So one of the nice things about talking to us too about any concerns that you might have is that we can channel them directly to some of the loudest and most prominent organizations in the industry so that we can get answers and results for you. So as you may know, the civil monetary penalties rule is in relationship to Section 111 reporting. It doesn't have anything to do with conditional payments. It doesn't have anything to do with Medicare set-asides. It's unique to Section 111 reporting. So we figured we'd show you what some of the basics are. Section 111 reporting involves data being reported to the government directly from responsible reporting entities. And if you're not sure of what that term is, RREs, and in Medicare world, and in particular Section 111 reporting, we do kind of have our own language. So we'll help you out with those things as well. So what is an RRE? It's either liability, including self-insurance, workers' compensation, and/or no-fault carriers. It's essentially anybody who has responsibility for making a medical payment and a bodily injury type of claim. And the purpose and the goals of Section 111 are avoidance and recovery. And I'll be very clear about that. Medicare secondary payer law went into effect in 1980, and a good bit of the enforcement didn't begin until the early aughts. Around 2007, Medicare realized that there needs to be some sort of infrastructure put into place whereby they can be notified whenever there are settlements, judgments, awards, and responsibilities for medical payment, other than them finding out randomly or having piecemeal correspondence sent to them. So at that time, the big two concerns were reimbursements of conditional payments that were already paid by Medicare and protecting futures in terms of Medicare set-asides. But these two hands never touched. There was never anything connecting them. And there was also nothing connecting the information and the data from these two responsibilities to Medicare. Hence, the Medicare mandatory insurer reporting requirement, whereby responsible reporting entities are legally obligated to notify Medicare when they have Medicare beneficiaries and responsibility for medical payments. And the purpose of that is avoidance, so that Medicare is not making payments when somebody else should, and recovery, getting paid back for any amounts that Medicare has already paid. So the idea behind Section 111 reporting makes a lot of sense. And when we go back to the whole purpose of the Medicare secondary payer laws, this is to make sure that Medicare isn't making payment when somebody else has the obligation to do so, to protect the financial integrity of the trust.
And we've had these rules on the books for quite a while. So the timeline of the civil monetary penalty rulemaking starts back in 2007, when they amended the Medicare secondary payer statute with the S-CHIP Extension Act. That got passed, and then it became effective in around 2010. Most REs started doing their reporting. Then there was another amendment to this, and it was called the SMART Act, and that happened in January of 2023. Now, the MARC Coalition that Michelle had mentioned earlier, that I'm pretty involved in, I'm on the executive committee of, and it's one of the only industry organizations that is really involved in lobbying and legislative efforts regarding Medicare secondary payer issues. So thank God they got an amendment passed called the SMART Act that made the civil monetary penalties for Section 111 reporting discretionary instead of a mandatory $1,000 per day per claim penalty. And, you know, to Michelle's point, what she had mentioned on the prior slide about Section 111 reporting and the purposes of Section 111 reporting, the civil monetary penalties are really designed to encourage compliance. And the agency as a whole, and all the discussions that we've had with CMS over the years, they're not interested in bankrupting insurance carriers, but the penalties they're stiff. I mean, they're big. And since this is such an old law, the inflation rate is pretty huge. And we're going to talk about that as well. It seems that, you know, the amount of inflation that has happened in the time since this law was originally passed and now to the actual applicability of the law is a lot, but a lot of time has passed. I mean, it's 2023, almost 2024. And, you know, the Medicare secondary payer law goes back to the 80s. And so we're really just getting around to proper coordination in this regard. And I think that has a lot to do with the IT advances that have happened over the last few years. CMS has aligned their different systems, they've aligned their contractors, and the information that we've been provided so far is that CMS as an agency is actually going to be doing their auditing on this, which could be a really good thing for the carrier community, because they're not taking a contingency off of what they recover. They're just looking at this from a common sense standpoint and a compliance standpoint, and they're really looking for bad actors, bad RREs, I shouldn't call them bad RREs, but RREs that are naughty, that are not following the rules. That's what I say to my kids all the time. Don't be naughty. All right. So we're going to tell everybody today, we're going to talk through how to not be naughty and how to not get in trouble, not get audited, not get penalized. So the original proposed rule was proposed in February of 2020. I'm not even going to go into the detail on any of that because we have a final rule and it's different than the original proposed rule, and it's different in a good way. And we're going to move forward and not spend a lot of time in the past because there's a lot to talk about in terms of what's going to happen in the future. They simplified this, and the final rule was published on October 11th of 2023 after CMS took a lot of time to review the comments that were made by the industry. They held a lot of meetings. They were in listening sessions, listen only during final rulemaking. But they heard the industry and they really did simplify how they are going to penalize carriers. There are still questions to be asked, but the final rule became effective on December 11th of 2023.
So the date of applicability, according to this rule, is October 11th, 2024, which is 1 year after the date it was published in the Federal Register. A lot of people may have gotten the alert on October 10th, but it's actually October 11th. That's the date of applicability, and then 1 year out. And according to the rule, no civil monetary penalty will be imposed until at least 1 year after the latter of the applicability date of the final rule, which would take you to October 11th, 2025, or the coverage effective date or settlement date, TPOC. And these are again, reporting terms of art, ORM being an ongoing responsibility for medical, or a TPOC, which is a total payment obligation to claimant. So I think what's good to know about this is there's no reason to think that you will get audited or that there will be fines assessed against you tomorrow. There's some grace time here. There's an opportunity to take a look at your program. And once we start getting into some of the information about how, when, and why you can be penalized, start applying that to what you're doing and make sure that you're free from risk.
Now, the earliest date a CMP can be levied would be what, Michelle?
Probably not until the latter part of October of 2025 or possibly later. And we're going to talk a little bit about what the process is with CMS and the pre-notification process and how it's going to occur. So there will be opportunities for RREs to hopefully have some sort of a conversation about any pre-notification that would occur too, which can add time.
Yeah, so the important terms that Michelle just mentioned are ORM, or ORM, as a lot of people say it. It drives me insane when people call it ORM. ORM, it sounds like ARM. And TPOC, so TPOC, like Michelle just said, total payment obligation to the claimant. So let's start with ongoing responsibility for medicals. This is going to be the hardest one to comply with, most likely for carriers. The trigger for ORM just recently changed this past summer. It used to just be an RRE's assumption of ongoing responsibility for medicals, but now it's defined as follows, okay? The trigger for reporting of ORM is the determination to assume ORM by the RRE, which is when the RRE learns through normal due diligence that the beneficiary has received or is receiving medical treatment related to the injury or illness sustained. Okay, so the big thing that changed here, and the important part for CMPs is that medical treatment needs to be happening. So I think for a lot of carriers, especially in the no-fault world, there was a lot of ORM being reported without knowing whether they went to a doctor. You could have a third-party claim. There could be, multiple people injured in, I'm just going to use a car accident, for example. And the carrier knows they have coverage and they want to get it reported, but they don't really know what happened. Maybe somebody at the scene took a report and said, I got whiplash, or, oh, I hurt my neck. But there was no doctor's report. There's no ER visit. There was no diagnosis codes. So CMS really wanted to discourage over-reporting out of fear. So my understanding of why they clarified this language, and this came from some discussions with the MARC Coalition and different carriers and industry concern that ORM was being reported and beneficiaries' benefits were getting cut off, but nobody really knew what the actual injury was. They knew there was coverage, but what's the injury here? So CMS clarified this, and they really want you to use due diligence. And what is normal due diligence? You could probably define that 100 different ways, but they want you to go through your normal due diligence, whatever that is for your industry and your claims, and figure out what the actual injury is. If there's no injury, there's no reporting. The effective date of ORM is also going to be really important because you are going to be penalized as an RRE based on your timeliness for reporting. So what is the effective date for ORM? It could vary. It could be the date of injury, the date of the accident. It could be the date of diagnosis in certain cases. It could be the date that a court finds that it is a compensable claim. Or it could be the date of injury and it's backdated because the court doesn't find that it's a compensable claim that you have ORM for until years after the claim originally happened. So there's going to be definitely some discussion needed with the agency because they are going to penalize for timeliness based on the assumption of the ORM. Now, in their reference guide currently, it states that the effective date for ORM is the date of injury, regardless of when the beneficiary receives their first medical treatment or when our ORM is reported. I think that that's probably going to end up being a bit of a stretch in certain cases, and that might not apply in certain cases, but I think you'll have an opportunity to present the evidence to prove when ORM actually started and what your actual coverage dates are. I'm thinking of situations where there's multiple carriers. And workers' compensation claims, you have multiple different coverage dates. You have the same date of injury in 4 different carriers that have coverage over a span of 10 years. So there's going to be nuances to this. It's not going to be perfect. It's going to be hard to write a perfect rule to surround how complicated ORM can be. So we'll see what happens with that. Now, with regard to TPOC, much easier. So this is easy peasy. This is the date the payment obligation is established, which is usually the date of settlement, the date the release is executed, or the later of the court approval date, or the date of the release being executed. It could be the date of the judgment if there's a trial or a jury verdict award, the date of the verdict. If there's no written agreement, CMS's reference guide provides that it's the date of the payment or the first payment if there's multiple payments. Pretty straightforward. There we go. Next slide.
So what can an RRE be penalized for? The big question is, what constitutes noncompliance? And in the final rule, noncompliance is defined as an occurrence in which CMS identifies a new beneficiary record, and that is italicized and emboldened deliberately, that was not reported to CMS in a timely, also emboldened and italicized deliberately manner. So it's whenever there is a record that is not reported timely. We have questions about what some of this terminology is, particularly the term record. Civil monetary penalties will only be levied in instances of noncompliance based on timely reporting of TPOCs and the assumption of ORM, which Kira just described. So any previous iterations of the rule that might have addressed proper ORM termination, errors hitting a certain threshold, error codes, error responses that might have hit a certain threshold, contradictory information being provided to Medicare, perhaps about ICD-10 codes. That is not relevant any longer. It is about timeliness. And that is what Medicare is identifying solely as where noncompliance occurs. So some questions that we've already put together that we're hoping that we can get clarification from Medicare are how will CMS audit timeliness if no record is reported? What Kira had recently just said is that Medicare is looking not to punish people who are making a good faith effort to report, but those who are naughty and who are not reporting it. If there's no record, if there's no reporting, how is civil monetary penalties going to apply to those actors? What is the definition of record? There are all kinds of records. Records is a term of art in Section 111 reporting. There are add records, update records, query records, delete records. Are these the records that Medicare is referring to when they say a new beneficiary record that was not reported? Or are they referring to a claim? Are they referring to a particular date of loss? Or are they referring to a beneficiary? We have questions about what they mean by that. Another issue, ORM and TPOC can be reported in the same record. ORM might be late and the TPOC could be timely, or both could be late, but the time frame of noncompliance may differ. How is Medicare going to look at penalties? And when we get a little bit further into the presentation, when we talk about some of the grading and scaling of offenses, you can see how this could be problematic in their analysis. Again, another big question that we have for Medicare. And will penalties be assessed by beneficiary? It was previously believed that the $1,000 per day per claim was relevant to a single claimant. But this term record is a distinction from what the original verbiage is. So we need to know, is it per claim? Because any beneficiary could have multiple claims that could have multiple reporting risks associated therein. So the way that Medicare has worded this, it appears to be a simplification of what was initially proposed. And there is clarity, more clarity in this rule, but there's still a lot of questions that we have that we need to get more answers on.
Yeah, and we have time, right? So the first, the earliest, like Michelle had said at the beginning, that we could be assessed any penalties on this is 2025. So we have plenty of time to talk through all of this with CMS. So timeliness is going to be determined by comparing the date that the record is submitted and accepted against the date CMS should have received the record. So again, one of the main questions for CMS and one of the main points of conversation is, how are you going to penalize RREs that aren't submitting records? And if the only method of penalty is to penalize those that are submitting records, what is the benefit to submitting records at that point? So lots of questions, but that's what they're going to be looking at. So the date that CMS should receive a record is determined by either the effective date of coverage, which is what we had talked about a couple slides ago, or the TPOC date plus 1 year. So, for example, if ORM is assumed on January 1st of 2027, the RRE has until January 1st of 2028 to report it. If you don't report the ORM, or that RRE doesn't, until March 1st of that same year, the period of non-compliance is actually January 2nd through March 1st, according to the final rule. So you're not non-compliant from the date of the ORM assumption forward. You're non-compliant from the date, the last date that you should have reported it forward. And then it's a daily penalty. So one of the takeaways from all of this is how is CMS going to determine when ORM is assumed? They're going to be auditing, so there's some assumptions that could be made that they're going to somehow audit the RRE such that they get enough information from the RRE to figure out when the accident occurred and then when the carrier picked up the claim. So more to come on that. But their audit methodology is probably going to have to really be made a little bit more transparent before we, start seeing CMPs.
something else that we have questions on. But I do have to say this, Kara, now that you've said ORM, and I'm hearing ARM every time I see it, that's what I hear. But I also have to mention to you that my pet peeve on reporting is hearing people say Tupac instead of TPOC. So just throwing that out there.
I've never heard that. Oh
ORM
my gosh.
Tupac, yeah. Okay. Anyway, see, we have to find our
Tupac.
Yeah, we have to find whatever comedy we can. All right, so CMS audit methodology. And this is a very big question that the industry had. How is Medicare going to go about this? Are they going to be hiring a third party, as Kira had said? Are they going to be bringing some RAC auditor in who is going to be looking for violations and getting paid a contingent fee to do so? Is it going to be bounty hunter style? What Medicare has issued in the final rule is that CMS will randomly select records quarterly to audit. So this is going to be something that it appears that they will be taking on as a task themselves, and that CMS will review each selected record to determine if it complies with the reporting requirements. That sounds like a careful, individualized review by CMS, which is a very good thing for RREs, as opposed to other ways that Medicare conducts auditing, for instance, in fraud cases. And when we talk about those contingent fee bases, we have other programs and other auditing possibilities and options out there where Medicare isn't doing an individualized review. So this appears to be very good for payers who are making a good faith effort. CMS will select 1,000 records to review on an annual basis, and we believe that this is spanning across all RREs. And as of right now, in the final rule, it is outlined that there are 21,000 registered reporting entities, 250 individual beneficiary records per quarter, and there is going to be a pro rata split between group health plans and non-group health plans. And that's something that we're going to want more information about as well. We want to make sure that this is 1,000 records across 21,000 RREs and not per RRE per year. And we want to know more about what that pro rata split is going to look like.
Yeah, and to a lot of carriers, that probably doesn't sound like a very many records to audit. To put a little bit of perspective behind those numbers, if they were to take a 60-40 pro rata split, so 60% of the group health plan records and they audit those, or 60% of the 1,000, so 60% of 1,000 will be group health plans, and then 40% will be non-group health plans. They still estimate that in the first year of penalties that they're going to penalize the non-group health plans for upwards of about $40 to $43 million in the first year. So it's still a lot of penalties. It doesn't reach the economic threshold for a full economic impact analysis, which is $200 million. But it's still a lot of money. And to dive into this a little bit further, this is how they're going to figure out what your daily penalty is. So the final rule outlines a tiered approach to CMPs. So that basically means that each day of non-compliance will be penalized according to a sliding scale based on how late that record is. So if the record is reported more than 1 year, but less than 2 years after the required reporting date, your penalty on a daily rate is $250. If it's reported more than 2 years late, but less than 3, it's going to be $500. And if it's reported more than 3 years, but just more than 3 years, but less than, well, it would be less than 5 because there's a statute of limitations. We're going to get there. It would be $1,000 per day for a penalty. So when you're looking at this and you're thinking, okay, how am I going to calculate what my total exposure is? You're going to be counting, and we're going to do some examples. You're going to be counting from that first day of noncompliance out. Now, one of my main questions about this is, say you reach year 4, is your daily penalty, because you're more than 4 years late, $1,000 per day? Or is it $250 for the first year of noncompliance, $500 for the second, and $1,000 beyond that? And once Michelle's going to talk to you about inflation on the next slide, and we're going to talk about what these numbers really are 20 years later. They also mention an annual cap on penalties. But again, this annual cap will be adjusted annually under the federal reg that outlines the civil monetary penalty inflationary rate. And that is 45 CFR Part 102. So currently, your annual cap on penalties would be $521,000, around that number. So again, you're not at 365 anymore. But the other thing to note is it a cap? So I don't know that this is actually a cap or if it's just the max penalty for a year. So the max penalty that you could have in a year is $1,000 per day. So the question really becomes, is it a cap on an individual? Because they mentioned individual, so that would be a beneficiary maybe, or is that an RRE? And they also use the word instance in different comment sections of the final rule. So those are some questions we want to ask CMS. Is their intent to have some sort of an actual cap that isn't just the amount of the max penalty?
So let's talk about that inflation. This is not arbitrary. This is regulatory, and the regulations that are cited in the final rule correspond with other inflationary adjustment regulations that are applied to other agencies and departments within the federal government. So these are not specific to Medicare, but specific to agency and administrative law. And if you want to take a look at 42 CFR 102.3, which Kira and I did just for fun, we wanted to take a look and see how this is written out. And it's interesting because the daily maximum, according to the regulation, is a little bit different than what is issued in the final rule. So we were a bit of watchdogs on that particular one. So if you take a look at what is here within the Federal Register, you will see that the max penalty, instead of $1,000 per day per report, is really $1,428 with that 42.8% inflation Kira had referenced, which, by the way, it's not necessarily a 42.8% inflation per year. This is without us giving you a compound interest calculator, just to make it simplified. For the $250 per day penalty, it's really $357 per day. And for $500 per day, it's really $714 per day. Now, this is all for 2023. Inflation will go up each year. The regulation will be updated each year to reflect larger values as we go. So even if a couple of cases are considered to be non-compliant, if you even had 4 of them that were at maximum penalty, you're looking at over $2 million in penalties for 4 claims. So these are significant.
Yeah. And we're hoping that we can get some clarification from CMS before they actually promulgate the final language on how and what the amounts will be in terms of how the penalties will be assessed. So currently it's 42 CFR 402-105B3. That would probably be a mouthful for most people that haven't practiced in MSP for the last decade. So we've gotten used to being like the farthest down in the food chain in terms of where we are in the reg. So there's also always multiple numbers and letters that come before you get to where non-group health plan Medicare secondary payer is in the reg. So you can see this little red line on the screen. That is where the language establishing the amounts of the penalties imposed is going to be. And hopefully there'll be very clear guidance in here in terms of max penalty, annual cap, how it will go. Will it be $250 for the first year? Like I said, $500, then $1,000. Or, you know, would it, if you hit the 1,000, is it 1,000 per day regardless? And we'll just see how that goes. And then how the max penalty shakes out. We have a little example for you. And I noticed that all of our examples use my birthday. So now you all can know when my birthday is. My birthday is January 1st. And it's our favorite example day. So you'll now all remember my birthday. I take cards and cash, work.
And my birthday is 4/28, which is the max penalty for 2023. So nobody likes either of our birthdays right now. Mine's the interest rate. So for calculating the civil monetary penalty amount example, which is in the Federal Register Final Rule, if you have a TPOC date of January 1st, 2025, the RRE has 1 year, 365 days from the TPOC date to report, which would be January 1st, 2026. The RRE reports this on October 15th, 2026. CMS has 5 years from January 2nd, 2026 to levy a CMP, and that's that statute of limitations applying. So if CMPs are imposed, the RRE will be considered non-compliant for the period of January 2nd, 2026 through October 15th, 2026, which is 286 days. So that would be the $250 per day per instance penalty, which is now $357, for a total of $102,102. So that's kind of how that plays out.
Yeah, so it's a pretty hefty penalty. Now, the next question becomes, what can you do? What can you do to mitigate civil monetary penalties? What can you do as an adjuster to make sure that you are doing the right things with regard to Section 111, that you're putting things in the right place? There's a lot you can do, and you have time to do it. The first thing you can do is get familiar with the safe harbors from civil monetary penalties. So the first safe harbor is something that is CMS's fault. So if CMS has a time delay or anything that's happened with their system that has caused some sort of a delay with reporting, which does happen. There are glitches, there are system outages, there are delays on reviewing claim input files and getting things back to REs. That would be a safe harbor. So if you're late because of anything that is the fault of CMS, that's one safe harbor. Another is compliance with reporting thresholds and any other reporting exclusions. So if you're not familiar, we do not have time today to go through the entire reference guide of reporting exclusions, but we will be doing more webinars, more trainings on this issue. And if you ever have questions, you can always reach out. But one really popular exclusion is the work comp exclusion, which is when you have a case where you have a injured worker that has missed less than 7 days of work, or whatever your state statute is, as long as it's less than 7 days of work before they've returned to work, you have spent less than $700 or $750 or less on medical expenses, which is really hard to do, unless they're not treating. There's health insurance, or healthcare, I should say, costs so much nowadays that none of the payments have been made directly to the injured worker. They've only been made to medical providers, and you have not paid any indemnity. There's no indemnity. So these are your medical only claims. Those are excluded from reporting. So these are like your finger lacerations, your simple cases where there's not a lot of treatment. There is a claim, but there's not a lot of treatment. They don't want those reported. You've got your pre-12/5/1980 exposure cases, a fan favorite. And then you've got all of the reporting thresholds, and there's more. So, but basically, in the next 2 years, as an adjuster, take as many training courses as you can. Hopefully your business is offering those to you, or your carrier is offering those to you, and make sure that you know when you need to get these reported, when they shouldn't be reported, what you should be entering in your data fields. And at the end of the day, by the time they get around to actually starting the report, and these penalties are going to be prospective in nature and not retroactive. So if you did something wrong yesterday, it's not going to matter. Just figure it out before October of 2025. The next safe harbor is untimely reporting due to lack of cooperation by a beneficiary. So in this circumstance, you might have, it's very common in auto cases or third-party claims where you have a non-insured person that there happens to be a policy for, maybe an underinsured motorist or something like that. The person that the policy is covering is not a direct insured, and the RRE really tries to get the Social Security number of this individual. There is a policy available for them. There is MedPay coverage, but this injured party will not provide their Social Security number. The RRE will not be penalized for not reporting a beneficiary if they are unable to obtain the beneficiary's cooperation in getting their Social Security number. In a non-employer-employee relationship, you can't force someone to give you their social. And even sometimes in workers' compensation situations, you could have a worker that's provided a false Social Security number, or not provided one and have one. So it's definitely not the RRE's fault as long as they make a good faith effort to get it. So what does that mean? The good faith effort means that the RRE must request the query information at least 3 times. Once in writing, including email, once more by mail, and once more by phone or other means of contact, which can be email again. So as long as you do that and you keep that information for 5 years, which is their recommended document retention time frame for this, you should be good in not reporting. Now, if you make that first request and the beneficiary says, absolutely not, I'm never giving you my Social Security number, put that in your file. You don't have to keep harassing them. You don't have to ask them 2 more times. They've told you no. No means no. Okay. And the final column here. And this is more of something, again, that is CMS's fault. So if you have an incident of noncompliance that's associated with a specific reporting policy or procedural change that by CMS has been effective for less than 6 months, following the implementation of that policy or procedural change, or for 12 months, should CMS be unable to provide a minimum of 6 months notice prior to implementing, then you're not going to be penalized. So that's basically saying, listen, we understand that CMS is going to change their policies, but we are going to give you long enough to pivot and make sure you get compliant with that policy change. So you will have, it's a mitigating argument, right? So it would mitigate the number of days that you are late based on how much notice you were given by the government of that policy change.
And mitigating factors are exciting to Kira and I as attorneys because the possibilities are endless. Per the final rule, any mitigating factors or circumstances are welcomed, and a dialogue is encouraged to find solutions that are short of imposing a CMP. You'll get to tell your story. You'll have an opportunity to provide evidence in the event that civil monetary penalties are on your doorstep. You'll get an opportunity to provide evidence and talk it through with them. CMS believes it is the best interest of all REs to leave the informal notice process open to any reasonable submission of mitigating factors so that they are free to entertain all such documentation without strict limits on what it is or is not acceptable. This is great. They're not putting restrictions on what they consider to be documentation that tells your side of the story. That we can get creative. There's all sorts of opportunities available. So information and documents that lead to mitigate noncompliance or explain technical errors, etc. Common mitigating factors, we have to look first to what Kara had referenced as the safe harbors. Any documentation that you have that proves any of the safe harbors are met. And then we have to start thinking about what other documentation could be possible. And it appears as though you're looking to show that there was a good faith effort that was made. So anything that might show a good faith effort is probably going to be something that could be useful as a mitigating piece of evidence. Do you have policies and procedures for Section 111 reporting? Anybody who's involved in Section 111 reporting for your business, are they engaged in education and training, things of that nature? Do you have handbooks? Do you have your procedures written down? Is there access to it from all of the personnel who are involved in reporting? Have you had audits conducted? Have you had anybody do any consulting, a third party, a disinterested third party, take a look at your program to see how it's performing? Do you incorporate the results of those findings and work to improve your program? Those are just some ideas about what could be common mitigating factors. We, of course, haven't worked with anybody who's had a pre-notice or have civil monetary penalties levied, so we're not sure what exactly is going to resound with Medicare, but these are all ideas. Document retention policies, again, the statute of limitations. If you've got this documentation and you have these things, hold on to them, and keep records of them because you might need them at a later time.
Okay, so my favorite, the statute of limitations. So there was a lot of discussion about the statute of limitations for civil monetary penalties with CMS in listen-only mode while they were finalizing these rules. And one of the big things that the industry really wanted to see is that this statute of limitations would align with the Medicare secondary payer statute of limitations. But CMS explains this and it makes sense. The statute of limitations for civil monetary penalties is different because it's a regulatory statute of limitations for all of the CMPs. It comes directly from 28 USC 2462, and that is the amount of time that CMS gets to impose a CMP, and it is based on the time frame from when the noncompliance occurred. So what is that time frame? What starts that time frame for CMS? Now, I know they didn't change it to 3 years to align with the MSP law generally for conditional payments, which is 3 years. But the best thing about this penalty is it is not based on the date of notice. So if you don't report the claim and CMS doesn't audit you, that 5 years is to 5 years. So it still would be based on when you should have reported it, and then you're 5 years out, and then it's done. They can't keep looking for things that you forgot to report 20 years ago or 10 years ago or 15 years ago once this gets going. So how do you determine when your noncompliance occurred? Well, it's pretty simple. Your 366th day is when your noncompliance starts, from the date you either assume ORM or you had a TPOC. So on that 366th day, really hard for me to say for some reason, that's when your noncompliance starts. So January 1, 2025 TPOC is the example. Happy birthday to me. 1 year later, you hit January 1st, 2026. You've exhausted the time frame that CMS is giving you to report that. January 2nd, 2026 is your first date of noncompliance. CMS has 5 years from that date to audit you, look at this record, and assess a civil monetary penalty.
So another question that the industry had is, where is the due process in this? Is there going to be an opportunity to bring this to a neutral third party in the event that we don't like what happens with the pre-notification process? So discussion, who will conduct the appeals? The very beginning of all of this is the pre-notice. CMS will provide the pre-notice to the RREs prior to formal enforcement. And this is one of those opportunities that we had discussed to provide mitigating evidence and to have a conversation with CMS. The RRE will have 30 days to respond to the pre-notice and to present mitigating evidence to CMS for review prior to imposition of CMP. So this is the lead up to everything, and an opportunity to avoid CMPs right off the rip through the pre-notice opportunity. Now we get into regulations that, again, are applied to agency and administrative law, CFR 40219 and CFR 1005. Through these regulations, RREs will receive written notice at the time a CMP is proposed, and then they have a right to request a hearing with an administrative law judge within 60 calendar days. So this is a neutral third party. In our experience, many of the ALJs that are within the Medicare hearings and appeals are very familiar with conditional payments and Medicare secondary payer now. We're hoping that they will be likewise educated about this process too, having very good success with ALJs under the current climate. And any party may appeal the initial decision of the ALJ to the Department Appeals Board within 30 days. That decision will be binding 60 calendar days following the service of the decision, absent a petition for judicial review. So there's due process, there's opportunity to bring any considerations before neutral third parties, and there's a ladder to climb.
What can you do right now? Ask questions, look at your claims, think about what your deficiencies might be right now as a company, as an RRE, and consider doing an audit on yourself or an independent third party audit. Having someone come in and do a diagnostic review of claims, as well as company policies and procedures. And that will pave the way for you to mitigate civil monetary penalties and make sure that you're doing your reporting in a compliant fashion. The other thing is, when the government comes in and audits, there's going to be a lot of different opportunities, like Michelle and I had mentioned earlier, to present evidence to show CMS that as an RE, you might have made a mistake on a claim, but overall you are a good faith actor. So set yourself up to have those conversations and be able to prove it. So make sure you have policy and procedure manuals in place. Show them that you're doing independent audits once a year. A lot of our clients have been doing annual maintenance for years at this point, to just have someone come in like us and say, okay, let's see what you're doing. We're going to randomly audit a subset of claims. We're going to make sure that you're compliant. We're going to identify what you're not compliant with. We're going to fix anything. We're going to make suggestions. We're going to get you on the right path. And it works great. And it's really the best thing that you can do. Education, education, education. This is a constantly evolving area of compliance, but extremely important given the severe nature of the amount of the penalties.
And don't
are there any questions? Oh, sorry, Michelle.
I was just going to mention, don't forget too that making sure that your program is performing optimally also has other benefits other than just insulating exposure from civil monetary penalties. Just remember, any codes that you're reporting over to Medicare, and whether you're properly terminating ORM, whether or not those might be triggers for noncompliance, there are contingent liabilities therein, because this is going to affect your conditional payment risk. Anything that's being reported to them, again, the avoidance and the reimbursement, twofold purpose of this. So making sure that your program is performing optimally has other benefits as well.
So let's open it up for some questions.
Yes. Thank you, ladies. Thank you, Michelle and Kara. The session today was fantastic. We do have a few questions. So I will ask the first one. What happens when the injured worker self-procures treatments months prior to reporting the claim? What would be considered timely reporting?
Sure. So that's an ORM question, okay? If what you would do is you would document your file and you would look to see what your state law dictates in terms of what was your coverage period. So maybe they report the claim in October, but they started treating in August. Legally, under your state law, when should you have been responsible for the treatment? And usually there's claim filing laws and timeframes in every single state. So for purposes of a claim like that, you couldn't have reported it earlier than the actual beneficiary told you about it and you accepted it. So you have a year. So as long as they reported to you within the year from when your legal responsibility would have started, you'll probably never have a problem anyways, but get it reported as soon as possible once they actually report it to you.
Thank you. The second question, regarding the exclusion to having to report, when you say the medical can only be paid to the provider, does that mean if we pay medical mileage to the injured worker that the exclusion would not apply?
That's a very good question. And that really is something that we should probably clarify with CMS, because carriers handle that one differently depending on who you ask. From a practical standpoint, paying for transportation, because it's not a medical transport, isn't medical treatment. You're not paying for a doctor visit, you're paying for a taxi, so to speak. So a lot of carriers won't consider that expense to actually be a payment for medicals. Because once they get to the doctor visit might be $200 and they can discharge them and it's fine. That medical transport might have been a lot more, or the mileage reimbursement might have been a lot more. So that would really be considered more of an expense. But every carrier calculates, or I should say, not calculates, categorizes payments in their system in their own way. So again, looking at your own business practices, looking at how you're categorizing your payments. Is that an expense? Is it an actual medical treatment? And then understanding which pot you're paying it out of might be a business practice for your purposes, but may not actually constitute a medical payment for CMS purposes. So it just sort of depends. If you're paying for an ambulance transport for someone on a ventilator, that's a medical. If you're paying for mileage reimbursement, that's not treatment.
Mandy, do we have any other questions?
I have one more. How can I make sure my Section 111 reporting program is performing so that we can avoid risks of penalties?
I can take that one. Yeah, as we had discussed, it's probably best to take an independent look, have a third party come in and take a look at what your program is doing and to find out whether you've got mitigating evidence, whether you're documenting it, whether you've got good record retention policies. Here's another one, to make sure that your address, your RRE address is updated in the TIN reference file, because these documents that are going to be coming, the pre-notifications that are going to be coming, they're likely not going to be going to your TPA or whoever any of your recovery or reporting agents might be. They're going to be coming right to the RRE. So make sure that you're getting the correspondence, because there will be timeframes on that. But just to have a real, deep dive on what you're doing and how you're doing it, and knowing that you've got somebody who's evaluating it and writing a report for you, that's going to be helpful as well. If you've got time to do it, this is a great opportunity to do so. One more thing to mention is that Medicare according to the final rule, does intend to do outreach. So if you've got really specific questions, such as we do, there should be opportunities coming up in the new year where we might have opportunities to directly ask Medicare. Otherwise, Kira and I are deeply involved in these organizations that are going to have opportunities to have these conversations. So if you've got more questions, please let us know what they are.
Well, ladies, you did an outstanding job, and we've had several comments. They really appreciated the humor that you interjected. You know, a lot of this can be very, very dry, and you guys have done an excellent job making it usable and understandable. So I'd like to thank Debbie Wilson for coming on and joining us, as well as Kara and Michelle. This will be available to you on the Macro Pro YouTube website, not website, but I guess it's a channel. So check out this if you have any further questions and you want to just see it again, make sure you have all the information correct. It will be there for you within the next week. Until the next time, we will see you guys later. Bye-bye now.
Thanks so much. Have a nice day.
Bye-bye.